everybody. Thank you so much for joining. I'm super, super excited and looking forward to some of the questions that I may get coming up for this. Just so you know, and we'll see about the slides. I wanted to make sure that I could see everything. This is the, I have Contracts 101, but intellectual property in the virtual realm, protecting your work online through contracts and copyrights is what we're going to be talking about today. So everything copyrights, everything contracts, everything the apocalypse and working in it, and things that you should be thinking about. So first of all, who am I? That's going to be talking to you for the next couple of minutes. I'm Erin McClarty. I am an impact architect here. A little bit of design, a little bit of training, legal skills, people coming figure it out, all those other things. So I am a trade and have been doing this work for a long time. But I'm super excited. I always love talking creative and to creatives. So very excited to be here. First, one thing I want to bring out, I'm going to be looking at my notes over here because I can get chatty about these things, and I want to make sure that I leave enough time to ask questions, which we will be doing at the end. With respect to the questions, one thing that I want everyone to keep in mind, they can get really specific sometimes in this work. People can say, well, you know, if I use this type of work in this way, on this medium, at this moon, and I'm an Aries, what does that mean? And so the intent is for this not to be a personal session. I'm going to give you general information to give you context about things that you should be thinking about. If the work matters, which I'd imagine it does, or you wouldn't be here, then do make the investment in talking to an attorney or anyone else who may be able to help you better understand how to protect your work and how to honor the work of others. So the questions, when they get hyper specific, we may be moving around those, but it doesn't mean that they don't matter. This is maybe it isn't the forum for them. Also, if you, with the presentation, keep my slides, with the presentation, be your intentions. I want to make this as valuable for you as it is for me and talking to you. And so with that being the case, be thinking about, you know, is force majeure something that you've been one someone about? Make sure you ask the question in the chat. Or have you really been thinking about copyright and wanting to better understand how that relates to your work? Make sure to ask the chat. So be setting your intentions in terms of what's up to here, something that you want to make sure that you take out of this, and make sure that you advocate for yourself by including that in the chat. Some of this is going to be a review of a talk that I've given before because I didn't want to go into some of the nuance without having done a refresher. So apologies to those who have had a chance to sit in on it. Hopefully that's what it will be, is a refresher, and then we'll go into a little bit more specific in terms of topics. First thing I want to talk about is just a copyright. What is a copyright? I like to think of this the way that I think about friends when we were children. Remember, you would say, okay, to be my friend, you have to do X, Y, and Z and follow these rules. Some of you still may be doing that's effectively what a copyright is. It's saying, use this work to use my work. You've got to follow these rules. It's a legal right that attaches to a thing. What's really important here is it's the stuff that comes out of our brain, right? The things that we think up, but it can't just stay in our brain in order for the copyright to attach. So it's got to be reduced down into some medium, a painting, a recording, a sculpture, etc. It does have to be original. So shocker, we can't copy what someone else has done verbatim and copyright that. And there are some nuances in terms of cops, I've called them, but for the most part, it's got to be original work that you've developed. And the term for those are, they say life and being, so your life plus 70 years non-renewable. So it comes with a copyright. I always tell people, be thinking about the bundle of sticks. It's a bundle of sticks, and as with any bundle, I don't have to give you the whole thing, right? I can give you one, I can give you two, I may give you all of them. And so the bundle of sticks here is reproduction, adaptation, distribution, performance, and display. So being able to make copies, you've watched a movie, you've likely seen some disclaimers about an adaptation. That means making it smaller for the screen and maybe cutting down the time to distribute it to others. It speaks for itself, to perform publicly and to display publicly as well. The way that you price a license, which we'll talk about in a little bit, will depend a lot on the amount of, or the sticks that you've decided to give someone. Can they merely reproduce it? Can they reproduce and adapt? Can they distribute? Can they do all of it? Your license may be more specific, more expensive, sorry, for that. If they can, then it would if you just give them one of the sticks. But a lot of people confuse this, thinking, well, if I give a copyright or if I give rights, I have to give all the rights. And that's not necessarily true. So this gets a little bit tricky. When you reduce something down into the medium, whatever that medium may be, a writing, a sculpture, you have a copyright at that point. As soon as it's reduced down, you have a copyright. However, to enforce that copyright, you have to register with the Copyrights Office. So I have a copyright in the writing that I create that is inherent as soon as I put them down, as so far as they're not a copsies, they're original to me, etc. However, in order to enforce that copyright, let's say I find out that I've posted something online and someone has copied, pasted it verbatim. If I wanted to enforce a right against them, I have to have had that registered with the Copyright Office before I can really do much of anything. You can send cease and desist, something like that, but to go to court, you would need to have registered that with the Copyrights Office. So it's super important that when you create things, and one of the great questions I got in this group was, what about earrings? Anything that you want to be copyrighted, you need to have a copyright notice. That's important because when it comes to copyright infringement, one of the things that people would be looking at, so I would be looking at to see am I infringing, is was there even notice of a copyright? Sure, you've created this thing, but you may have created it in public commons, right? There may be some kind of commons license to it and it's public domain. There could be a number of different things. I don't want to go into the nuance, but in order to make sure that people know, hey, I actually do want to maintain the copyright in this, and I will report against you, I need to have a notice that when there's a copyright date and my name. And we see this a lot of times in documents, and in fact, you'll see it on these slides. Something else I want to mention when it comes to original, not everything that is reduced is copyrightable. A lot of people tend to be surprised, like recipes. It's not me, I don't agree with it, I think it's stupid, but recipes are not considered original. I know. Something else that's not considered original is, or that's not copyrightable, is processes. And this gets really tricky when it comes to things like choreography. When I reduce it down into a visual, that visual is copyrightable, right? But the process itself that I have reduced, the content itself is not copyrightable. I wouldn't be protected insofar as a copyright. I may need to try to file a patent or something like that, depending on what it was. So that's something a lot of people tend to be tripped out about, but I think it's really important to be thinking. So I've been getting a lot of questions from folks about using things online, worried about a copyright. Make sure I'm here. And so one of the easiest things to do if you're going to use content online and you want to make sure that you're not on the wrong side of someone's copyright is to ask them. It solves a lot of problems. And so just asking for permission rather than to see if offense is there real, is there even a copyright, is probably going to be the easiest way to go. Some people decide to just, they want to do their own legal analysis. I don't know if that's the route that I would want to take, but they do their own legal analysis to see, is there originality? You know, is there a copyright here? And if there isn't a copyright, in my opinion, then I may be able to use this content and it's not going to be problematic. That is a route. And as someone here to give you information, I am letting you know this is something you could do. I don't necessarily advise it for you, but it is a way that you may be able to use content online. In line with asking for permission, get a license. This is what I meant. Ask permission, and as part of that permission, have something in writing that outlines what you both agree to. I'm going to talk about the importance of contracts in a little bit, but the thing to keep in mind throughout the entire this presentation, and really anytime you think about intellectual property, it is not about gray area per se, in terms of we can make assumptions here and make assumptions there. Oh, well, she lent me this, so she must have meant me to be able to use this. But intellectual property has to be an express grant a permission. If I have not expressly said you may use X, you don't have permission to use it, and you are then infringing my intellectual property rights if you decide to use it. So it's really, really important that they be clear, whatever's content you're using, what content you can use, how you can use it, how long you can use it, where you can use it, how much does it cost for you to use it, you owe royalties. All of that has to be reduced down in writing if you want to save yourself a lot of heartache. Disclaimers. I don't own the rights to this music. Sound familiar to anyone? So I get this question a lot as well. This is just in my experience and from what I have seen, people say, hey, if I put disclaimers like that in my materials, on my posts, in my performance, am I protected? I want everyone to take a pen and paper and write this down because it's really important what I'm about to say. If I put disclaimers, am I protected? No, you are not. Disclaimers are only that, disclaimers. Anyone can sue for anything. So you still have to go through the process of defending yourself if someone says you use something of mine that you didn't have permission to use. And in fact, what a lot of attorneys would say is, if you're posting, I do not own the rights to this, it becomes abundantly clear to the world you didn't ask for permission and are likely in violation of use. So don't do it. Get permission. If you have permission, don't post it. So let's say you are using some content material. You want to know what the risks are. You're trying to weigh what your risks would be. So let's say I use copyright material. They say that I'm infringed. What rights do I have? What can I say? Fair use comes up almost always. It's the one that rappers use. It's the one that teachers often use. So you'll see that teachers make copies of an excerpt of a book and hand it out to the class. Technically, that would be an infringement of that copyright, but they may have a defense in the sense that there's a fair use. And I want to make sure I have this up because there's a whole set of questions with fair use that we need to be thinking about. One of those is purpose character. So education is always preferred over commercial when you're talking about a fair use defense. I have a right. Is this a fair use to where I won't be responsible for copyright infringement? Is educational commercial? Is it transformative? Transformative is the word of the day. This is what you hear talked about when you hear about the cases with Drake and Robin Thicke and whomever else. So with the that was the issue, right? Robin entirely different song. That beat was not transformative at all. It was the same beat used essentially. And so it wasn't a fair use in terms of sampling. And he was, as you probably saw, heavily responsible for damages. So the other questions to be asking is the nature of the copyrighted work. They tend to lean more toward technical uses, so a weather report or something like that, than a creative use. The reason for this is they want to make sure if I've copyrighted my creative use, that my creation is actually protected. And it's a little bit easier if it's creative than it is if it's like an almanac. And then amount used, of course, that's another thing that tends to become problematic for rappers who are sampling. If they start to sample a little too much, and it no longer becomes a fair use. And then effect on the market. So that's by you using this, does it devalue the ability first, or lessen the value of the thing? Was something else that came up with the Robin Thicke case was, okay, well, if he can just do a whole song, why would anyone have any reason to pay us royalty moving forward? And that was a fair case on fair use. So fair use, in summary, is a difficult doctrine. There are whole semesters taught on this. You may hear it used often as a defense, and people say, oh, you're fine, fair use. But be making sure that you're actually going through those sets of questions before you do that. Independent creation is another one. This there was a Beatles case clearly years ago that where a Beatles song sounded very similar to another song. And what the Beatles were asserting was it must have just been something unconscious. Either that it was unconscious, they said they hadn't had any touch, but essentially independent creation is even things that we have are incredibly similar, it is very unlikely that I've had any touch or contact with you, which created to where I would have been able to copy that and then replicate it to whatever it is that I did. And so independently, I conjured this up. Where the unconsciousness came in is that oftentimes there tends to be some meats that people tend to come up with. Similar landscapes. I remember seeing a scientific study where people were asked to draw a landscape, and eerily, people drew a very similar landscape without having ever met one another. There's just things in our consciousness that we all tend to default to when we think landscape or we think drop a bead. And in that case, then it makes it more likely that you can argue independent creation if you do create something that's very similar to someone else. And then this comes up will say, well, if I see a picture of a celebrity and I want to paint them, can I? Celebrities have a right to publicity. You have a right to free speech. Sometimes that trumps, sometimes. This is something that came up with Jeffrey Ferry case. It comes back to Tiger Woods. And so a lot of but it's work online. Sending incentives for low resolutions can be super important because it is easy these days for people to copy and paste. You might also deactivate the right click. So let me know if people are missing anything specific. There was audio issues and I talk very fast, so that probably doesn't help. Send snippets, and you can deactivate the right click if you want to make sure that people can't copy and paste. Like my blog, you can't actually right click on my blog to try to keep that from happening. And then have a CAN licensing agreement that you can slide people if you want to protect yourself. So if you post something online and you know people are going to want to use it, then already have a license developed that you can slide on over to them, outlining some of the things that we're going to talk about a little bit later. I always get fascinated by this case, and I tell it every time I talk about this. McClarty maps implants errors into their map. And so if you look, there's usually a city, some type of misspelling, there's a made up city or something that we won't know and can't see, but there's something in the map that makes it abundantly clear to them. If they see something similar and look, if they find that error, then they know it's been replicated. I think that is amazing. And so a lot of artists are known for watermarking their work. They're known for, I have a friend with audio recording. She puts subliminal things in there so that if you slow it down to a certain mark and use whatever technology, I would know, you can hear whatever that she's in there. So she knows whether or not people have lifted her, which I think is really cool. So that's another way to protect yourself, to implant errors works and that in the event that someone does create something error, you can see whether or not it actually was lifted from you. May have your copyright notice and attribution language, and then just clearly post what people can and can't do and your contact information. You hear this a lot with NFL and other sports. They say you cannot really fast in terms of you're not permitted to record or not permitted to reproduce, et cetera, et cetera, et cetera. Before you do your performance, that may be something to be thinking about, is if you don't, or you have expectations around how the performance can and cannot be online, just clearly post that and say that at the beginning, people know. Also that notice will have here, and leave your contact information in case they want to reach to you and learn a little bit more, get that license agreement, etc. And then be on the defense. So if you have photos posted, in the meta tags so that you can do a Google search periodically and see if they're actually using your work. There is a concept called abandonment. So if you're not properly monitoring use of certain intellectual property, it can argue that you abandoned it. It is another difficult doctrine, other word for the day, along with nuance, but do be checking from time to time to see if there are your work maybe out there. You have a better chance of having a claim in the event that someone does replicate your work if you've been searching and been active about being on the defense. So that's it for contracts. And I actually had a question. So I'll answer this quick because this is on, I'm assuming, on intellectual property. The question is posting you without permission an issue, even if you aren't making money off of it? Absolutely. Are you likely to have a, maybe not, especially if all you have to your name are cookies and sandwiches, which I know has been the case for me in some instances. However, does it mean that they don't have a claim? No. So even if you are making money, and some people say, well, solvent, judgment proof is what I hear from a lot of creatives, you know, all I have is debt. That may be the case. And what I had in one instance, which was really ironic, is I had a colleague that posted something, wasn't making money off of it originally. Things popped off of what she's doing. She adapted it for another use and made money off of that. And someone did come after her because of what she had embedded in the adaptation. And so I felt to say that the claims still attach, whether or not you're making money, whether or not it's educational, it can be a violation. The only thing that plays into is whether or not someone is likely to even bother coming against you in terms of judgment. You may get a nasty note. They may send you a cease and desist. That happens a lot, but they may not decide to take you to court. So contracts, talk about contracts quickly. I want to get this out of the way really, really quickly because it comes up a lot with my creatives that say, oh, you know, it defaces the work. I'm not about that. It's too businessy. There's some reasons I've noticed that contracts tend to make my creative clients flinch, and I have quite a few. There's definitely a manipulative, oppressive way that contracts have and continue to be used in certain environments. I will not argue against. I was corporate counsel for years and saw it myself. However, I don't think it comes down to doing contracts because you don't care about the relationship or because you're being super formal or you think too highly of yourself. Really what it comes down to is the awareness that you're attributing to yourself and to your work. Are you worthy of getting attribution? Are you worthy of getting paid? Are you worthy of honoring the amount of work that you put into the works that you create and having other people honor the work that goes into that as well? If you are, that's what a contract is for. So it's not meant for it to be a win-lose situation. It's not meant to be something manipulative. I mean, in fact, we're in a contract right now in terms of this relationship. We have contracts all the time in which they're not manipulative. So I'm all about reframing and modeling a different way of doing things. And that's what I would suggest for anyone who has had contracts because they felt icky or because they didn't like the way that they had been treated in contract negotiations. That's come up, especially those who have maybe with salaries and have the best negotiation actresses, another one, actresses who haven't had the best experience with contracts. There is definitely a bad way to do it, and there's definitely a very positive, collaborative, cooperative way to do it. And that's what I would advocate for. So in summary, get contracts. And that's my fresh talk. So check these. Contract is what you make of it, and again, it comes down to the amount of work that you're putting onto you and your work. I'll just say this because I think it's important that you know fundamentally what needs to exist to have a contract. I have to offer you something, you have to accept it, and there needs to be consideration between us. If we don't have all of this, a contract doesn't exist. I will not go into contract law. Where this can come into play is, let's say I offer to sell you something, a commission of money, but in a week. The offer is that until the end of the week, I'm willing to sell this to you. Don't accept within the end, but you do send me an email maybe 2 weeks later and say, hey, I'm ready to accept. That technically would be a new offer. And I could accept, but I wouldn't be in breach simply because I had offered to sell that to you because you had a week and you didn't do it within that week. So if you want, as someone who's creating something for someone, want to make sure that you have a binding agreement, whether it's oral or not, then make sure that you have presence. Honor, acceptance, and consideration is, I give you this piece, you're going to get money, basically. Why does the contract matter? One, it just gets all misunderstandings out of the way. Most of the time when I see claims come up for contracts, it is almost always because there was a misunderstanding. There wasn't something that was being clearly communicated. It's like in a situation where you're with a partner, you thought that you were hungry, they weren't really thinking about you, they don't get you something to eat, so you're mad at them for several hours and they don't know what's going on with you. It's all the time in contracts, trust me. So it helps get misunderstandings out the way. I also feel like it psychologically prepares people. And stop me if you've seen this, where you've had a potential patron or someone who is interested in your work that seems to continue to want to get engaged in these negotiations. You get a dozen emails, they want to have several different calls, and you don't feel like they're taking you or your time or your work very seriously. I find slipping that contract immediately starts to prep people up, because they know, so we're entering that. So this is being formalized. And if they're not serious, then they tend to drop off. Someone in negotiations isn't the contract, they tend to drop off. So it's a good repellent for that. And it also helps with building relationships. Again, just making sure that everybody is clear around what's about to transpire and take place in the relationship. It's also a memorialization conflict. I can't tell you how many, and it's been dozens of that I have worked with. We're working with family and friends and cousins and cousins' cousins and besties and all kinds of things that they trusted, institutions that they'd worked with for many, many years. And oh, we don't need a contract, which is usually the last words. And then 6 months, they come to me about what can they do because they haven't been paid. Things happen. People change. Conflict arises. It is helpful for no one if it comes down to a he said, she said. So having something in writing not only allows you to, it gives you a greater leg up if you have to go to mediation or eventually file a claim, but just refresh your memory. So if the client has said, no, I distinctly remember you told me you were going to have it by this date, and you're like, nah, I told you I was going to have it by this date. How easy is to get a contract and say, oh, this is what it says, because hopefully you will have the date in there. So for memorialization as well. I am going to run through putting together a contract because I want to make sure I leave time for any questions for anyone that has it. But we can go back to it if anybody wants to talk about anything more. Biggest takeaway, make your expectations clear. If you don't expect to sell a sculpture with a stand, say that the stand will not be included. If you expect the client to respond back to you in a week, because that's what it takes for you to get whatever it is that you're doing done by the specific deadline, say that they must respond in 7 business days. There's so much that we leave hands. A lot of people feel that they need to use human for flowery language. I take a law degree, say you need to respond in 7 days. Some other things that may be important, and folks like myself are happy to have that, but in terms of details, that's something you probably know more than I do. Can more clearly explicate in your contracts when you have them. So don't leave at the chance. Don't necessarily assume that people know that you need to have this, that, and the other in order to do the work that you're doing. If you need certain prints or approvals or whatever the case may be very clear about that in your contracts. So announce anything that scares you and keeps you up at night. Make sure to cover that. A lot of times for folks, for me, that tends to be delivery, working with a gallery, loss, payment for commissions and things like that, or milestone payments would be another one. So anything that keeps you up, talk about. Oopsies. Stuff happens, right? People make mistakes. It's really important to talk about what that looks like. So if you create something and they're not necessarily happy, now, well, let me take it back. You may have a disclaimer about them being happy. If you create something and it was supposed to have 3 arms and you gave it 2, what ends up happening at that? You don't want to wait until that's happened to talk about what happens when that happens. Talking about oopsies ahead of time makes it easier for you, and it can also save you quite a bit of money as a creative if you're creating things. Talk about the process and what that's going to look like. Again, making your expectations clear in terms of how this is going to work. If you don't want the client popping up on your space, but you're doing what you're doing, and instead want to be able to present at a third party space, then put that in the contract, which is probably also really important now that we have, the COVID situation going on. your goals include, and then just remember that contracts are interpreted by the four corners of the document is what they say. So whatever is not in that contract technically doesn't exist. I have way many folks that I've talked to that rely on emails, dozens and dozens of emails, and there are instances where those emails may be included. It is rare. Really just depends on these facts. So I wouldn't, if you have a contract and then you decide to change the contract via email, I wouldn't just rely on that email. Go ahead and do an amendment or addendum to that contract. If you even have a contract, not judging you, but get one in place, and you're just relying on emails, then have a contract, because we're looking at the four corners of the document. You can create a contract through email, right? But that's a whole different thing. Be collaborative, like I said. So don't just draw up something that is totally, totally unfair to everyone involved except you, and then push that on someone else. Again, we're trying to model something different. So I often like to work with opposing when I can on, I hate the word opposing, but the other party when drafting contracts. I would suggest the same for you. Really big, address the breakup. Again, sometimes it's me, not you. And if that's the case, I want to be able to get out of this. And the worst time to talk about what happens when I want to fool with you is when I don't really feel like fooling with you. So don't wait until you hate each other's guts to talk about what happens next. Do it in the beginning. A lot of people think this is something that's not going to happen, but again, it happens. A lot of folks having to do breakups right now with pandemic, and I can't tell you the number of contracts I've seen where people just didn't talk about what happened. So we don't know how they're, well, I hope we figure they don't know how they're getting paid. They don't know when they don't know if they'll get paid, right? Because none of that stuff was discussed in the contract. So do be thinking about the breakup, the things that scare you, and be talking about this in the actual agreement. Do not title it breakup, though. Felt like I needed to say that just in case. Other things to include: be specific and clear. Your scope is essential. Way too many people say scoper, and that's it. That's not going to be terribly helpful for you if something comes up. Be very specific about, what is the piece? What are the dimensions? What are the colors that you've agreed to up front? Is there a rendering, in fact, that you can include just so it's very, very clear what you expect to deliver? Now, I use sculptures for some reason. I work a lot of sculptures, but that's with anything. If I'm delivering a mission poem, it's going to be the same case there too. Talk about payment and make payment for you. Oftentimes when I'm working with creatives, they'll have to where most of the payment comes in, but all their expenses in the beginning. So if the contract make it until the end, now you're trying to recoup and cover the costs you may or may not get, depending on why the relationship is ending. So you may not be able to recoup all, but try to keep payments, especially milestone payments, up with what your costs incurred actually are, so that you're not at the end dragging along trying to get these big lump sum payments that you really should have gotten in the beginning. When I say total costs, I mean costs for materials, supplies, delivery, postage, drop cloth. I mean, if there's something that you need to be reimbursed for, include that cost in there so that that's not something, again, trying to recoup the fact. Talk about intellectual property rights, who owns what. If you are going to own it, what licenses do they have? What can they do? What can't they do with it? Or giving away intellectual property, then what can you do? Licenses you have when you see the whole rights of show provisions and these types of agreements. So when things go left, who's responsible? If the piece does get damaged in delivery, who's going to be responsible for that? Especially if the client that you deliver it personally because they just love seeing your face. Total liability, how much are you going to be responsible for if something happens? And then, so special damages, this is really important, I think. I'm trying to think. So this came up recently, actually, where, I don't want to use an example because you might know who these people are. Let's say hypothetically, you are working with an institution. You are commissioned to do something. Maybe it's to write some words, it's to create a mural, and It's in relation to a larger project that's under contract for another client. So the institution is under contract with another client, and they subcontracted some of that to you to create a mural for the piece. And you don't get the mural done in time, which means space doesn't open, which means that the person that was your client is now in breach with the contract they have with their client. Their client could come after them for damages, which means they may come after you for damages. What you want to do is be able to disclaim anything that is tangential, anything that is not related to your direct relationship, your client. You want to try not to pick up. And that should be abundantly clear. You and I, this is between you and I. Whatever happens with your client is your business. So especially with any type of prime agreements that get subcontracted, you want to make sure that you have special damages in there and that you limit your warranty. I'm imagining you don't want to touch up a mural for the next 80 years. Maybe you do, maybe you don't. Maybe you don't want to have to fix a sculpture that gets dinged or ditched or deteriorates over the next 40 years. And if that's the case, then you want to limit your warranty. So what will you do in terms of repair, replacement, and maintenance? Will you do maintenance? What won't you do? Are you a charge? It's something that's not your fault. So oopsies, they've dropped it. Is that something that you cover or not? Again, you don't want to leave that up to chance, and you want to make sure that that's clearly outlined. Permission and laws, if they have you on the site, do they have permission to have you on that site? Warranties, I talked about that. Termination, administration, dispute is going to be another biggie. So what happens if we don't like each other anymore? Force majeure has come up, and I want to make sure I'm on time. Okay, I'm doing okay. Force majeure is another one that's come up quite a bit. A lot of people didn't have this in their contract. If you've been paying attention to the dumpster our reality right now, a lot of people are regretting not having that in their contracts. A lot of creatives actually are regretting not having that in their contracts. Force majeure basically says, if we can't form this agreement for whatever reason that is not our fault, then this is what happens. You pay me this, I pay you that, we're in the agreement, we postpone the agreement, it's standby, you pay me while I wait for you to get that stuff together. A lot of people who are dealing with canceled event spaces, canceled commissions, and things like that. Force majeure, right? What happens with cancellations? Do you postpone if something comes up? If a raw material that you need for your piece is no longer available, does that allow for you to get out of the contract? Or do you hold off for a little bit to see if the piece does come available? Are you able to substitute it? Force majeure is going to talk about all of that. Super important. If you have not had force majeure in your contracts currently, start putting that in there, because I would imagine it's only going to become more relevant. So what if I don't have a contract? You've been talking about this, Erin. I don't have a contract. Then you'll need to assess whether or not you're better off. Usually you're not. But you'll need to assess if you're better off. And you know, what's the risk, you know, in terms of you not being paid, there being an infringement of rights in terms of ownership that you have in the piece, or an infringement of their rights if they have the piece. Is even discussed who's going to have rights in the piece. And for me, usually I recommend drafting something. It may not be as comprehensive as it otherwise would have been, but I always err on the side of something in writing. And the way that I frame that for some creatives that have come and talk to me that we need to get a contract in place is to say, all right, let's group what you're doing currently under phase 1. And for phase 2, for ongoing work, to that last point, we're going to memorialize things. So it's what your responsibility is going to be. So what do you do if you have a janky contract, which some of you may have? Again, assess your risk and see where you're at in terms of some of the things that we've talked about today. I suggest an addendum. So again, erring on the side of getting it memorialized, clean up to the extent that you can. So you say, oh man, I didn't talk about force majeure, I didn't talk about ownership, I didn't talk about licensing. Use this as an excuse, right? Hey, I was at this presentation. This charming attorney who mentioned these things, and then put that in an addendum, right? And then it's possible that you may get a new contract too. I've had some clients that have had clients that were understanding enough, and they also saw the risks that they had into those contracts. Details weren't talked about, and said, you know what, yeah, let's do this over. So even if you have a janky agreement, that's not to say that you should just let it remain janky. It may be worthwhile revising it. So as we work during this apocalypse, what are things that we need to be thinking about? If you're translating your work online, what licenses cover new use? Or do your license cover new use? Where this comes up is, I've embedded some content of someone else's and they have licensed that content to me. Usually that license will say what I do, what I can't do, where I can do it, for how long, and what way it can be presented. And so they may have licensed things, and now I'm thinking about doing it digitally. And so my new use may not be covered by that license. And I'll need to go back to them and get that, because if I don't, I'll be responsible for infringement. So if you are translating previous works online, make sure all the licenses that you've had actually line up with your new use. Also, I read in the Fresh Arts summary, was talking about platforms. I thought, yes, and whoever is responsible for that, Marcy. This is absolutely something to be thinking about. If you read the terms of use on a lot of platforms, really, so be looking at what are their license rates. Sometimes they say we have a right to all these different things. We can put you on a homepage, which is pretty innocuous. You may want it put on your homepage, but that is others have their uses. They can use it for whatever internal business, and they don't necessarily define what internal business is. And so as you are things online, be reading, if you haven't been, the terms of use to see what rights those platforms have to the work that you're posting and what licenses you're giving them, because you are giving them licenses when you post and use those platforms. What permissions you're allowing people to have. So again, as you're posting your performances and things like that, can people replicate it? Can they duplicate? Can they adapt? If they can't, be clear about that in your posts. So again, you have those notices. And if you're creating microsites, I always suggest terms of use. So having something that outlines what people can do, can't do, how they engage the site, what happens if they do things wrong, ability to kick out, etc. E-commerce, a whole thing unto itself. The biggest things that I've noticed start to come up are, one, collecting taxes. I don't know about you, but I'm getting notices from everybody in the mall about collecting taxes in Texas. Actually, I think Fiverr or Upwork, one of them just sent me something a couple of days ago, said, hey, collecting taxes in Texas now. The reason for this is a lot of the comptrollers have said, you know what, you may be online, but you still technically have a presence in our state. We're going to be expecting you to collect taxes to pay us. Whereas a lot of folks didn't think for a while that they need to collect tax because they didn't have physical presence in the state, they're now required to do so merely because their website has a presence or is being accessed by someone in the state. And that's the case for a lot of different states. So I say that because as you create your e-commerce sites, you may be responsible for collecting taxes in states, even though you've not ever set foot in that state. It's a state. The platforms are really good about helping figure this out, and they'll actually default depending on your location and some other really snazzy things to help you figure out when you be collecting taxes and then do that. QuickBooks, the QuickBooks app that does help you with that as well. So there are technology that do, but be thinking about that. Again, because old taxes get paid, and so it's either you or it's going to be them. So be thinking about collection. If you don't need blood type and astrological sign, don't be asking for those, because the more data that you collect, the more you are responsible for, and it may be the more security you need to make sure you have in place to make sure that there aren't hacks. As you can imagine, the hacks on nonprofit and small business sites has gone up exponentially. Why? Because they usually don't have protections in place. And it's easy to get that data, whether it be credit card, email addresses for the black web, etc. So be careful with the data that you're collecting, and know that even when it comes to things like newsletters, you need to have a privacy policy in place, and you need to have a process in terms of what happens with data, where is that data stored, what you do with that data, and what happens if someone wants that data deleted or wants to know what data you have on them. Especially important for those who have a touch in the European Union, where folks from the European Union are accessing your site, because GDPR applies as well. There's a whole set of rules around that. Terms of use, make sure you have terms of use, because you do want to talk about what expectations are with your site, what they can't do, what you're responsible for, returns, payment of taxes. If they have to set up an and it's a fraudulent account or they're spamming, like what are the process for all of that? You want those things outlined. If you're getting brands, so websites, logos, who owns that? That's something a lot of people forget to ask. When you're using these cheap generators, oftentimes in terms of use, if you read them, which means you have to read them, it will say that they actually own the logo that they sent you. Not only that, but they're giving you a non-exclusive license, which basically means they can duplicate that logo as it is and hand it to someone else an hour later. So if you want to own your branding, it needs to be abundantly clear in contracts with your freelancers, whether they're on Fiverr, whether they're on Upwork, or if you're using one of these generators, oftentimes you'll have to pay a much higher amount when you get the copyright, things like that. So be looking at that, making sure that actually you want to own your branding. Also be thinking about Deceptive Trade Practices Act. Well, I'm thinking about the statewide one. There's a bunch of different laws around it. So things like, if there isn't a warranty on what you're selling, then don't say there's a warranty, right? If you post something online for sale, it needs to actually be on sale, because if I paid for it and it turns out it didn't exist and you don't end up sending it to me, then you may be responsible for a deceptive trade practice violation, and that's up to $1,000, I think, for each one. I won't talk about more SEO. So a lot of people are starting to reach out to me. I don't know about you, looking to do SEO services. Some of the problems, they use tricks that are a violation of Google's terms of use. Again, something to read. And what can happen is you get penalized basically on your account or your site. And so you want to make sure that you are asking anyone that you hire to do SEO for you in your e-commerce, what they're doing, if they're complying with those rules, or what happens if they don't. Because you'll get penalized and you may having to pay some damages if it's bad enough. And then if you use influencers, be thinking about social media sweepstakes law. They've got to make a disclaimer that it's an ad. It needs to be abundantly clear that they're being paid, etc. We're almost done, folks. We're rounding it out. So be thinking about your questions, any questions that you have around contracts, e-commerce, online, or still copyrights, if you still have questions on copyrights or intellectual property and use of that. Other things to be thinking about: if I have my works in a gallery, of gallery tours, who's responsible for that work? If someone breaks into the gallery because no one's at the gallery, am I responsible for that? Is the gallerist responsible for that? Is there a contract that talks about that? Something to be thinking about, because a lot of people are going to have their works in places that are not as heavily frequented and patroned as they were, which may lead to things like that. And if I've bought software for a certain time of use and I'm using it heavier these days just because I'm having to go virtual, does my license accommodate the heavier use? So, if I've worked for an organization and I was using the license for that organization, and now everyone in the organization wants to use that license, was it one seat, in which case I can use, or was it a personal license to me, or is it something that I actually can sub-license to my colleagues? Usually I can't. It's just something that you want to look at, it to see, as you're doing things more virtually and use software more, do those licenses translate? And force majeure, we talked about that, making sure your contracts have something about cancellations and postponement, because as we go back and forth, red light, green light with the opens and closes in Texas, it may be that you were on board when you signed the contract and it seemed like everything was going to happen, and then all of a sudden everything closed again, and you want to make sure if you've had costs incurred or really just anything that you're on the hook for, that's getting passed through, or at least equitably disseminated between you and the person that you're working with. And then, back to disclaimers. So I've seen a lot of people reaching out, turning, saying, hey, can you draft me a disclaimer that if anyone catches COVID, I'm not responsible? And there's questions of, is this enough? So all of this is new-ish, right? I think this last time was like 1912, this stuff happened. So there's not much case law, as you can imagine, on global worldwide pandemics and contracts. So we're all figuring this out together, which means it could be enough, it could not be enough. I would say that there has to be proof of your responsibility, right? And so with contact tracing, that may be possible. It may be hard for someone to prove that your market on March 18th is the one that was responsible for contracting something. However, you could be responsible for negligence. So if you are hosting or thinking about hosting things in person, just know that by having people sign a piece of paper does not mean that they cannot and will not sue. It may mean that you should be responsible ultimately, but that's only after you've expended costs for an attorney and all the other things that go involved with defending yourself. So be careful with those. Whew. So with a few minutes left, I am happy to answer any questions. Remember, hyper-specific is for another time. I don't know if there was any other ones that came through. I can say really quickly what I have been thinking about that has come up with force majeure that I'm telling a lot of creatives to be including, anticipating for, is really just working collectives, in collectives as cooperatives, and then having not only the agreement for the collective and cooperative, having that cooperative have the agreement with the client as another way to disperse costs. So rather than me taking on a risk of not opening up and responsible for costs for a space that I just, at the end of the day, I really can't afford because of everything that's happened. Why not have 12 people in a collective sign some type of joint venture where we agree to split the costs? If it turns out we can't be with that collective, that's something that we're all for, necessarily just myself. Thinking maybe a little bit more creatively about how to protect yourselves for writers and dancers, revisiting maybe your agreements. Oh, I heard it's choppy. Let's see. Well, revisiting your agreement, let me know if it gets, I'll take this out. Maybe that helped. Let's see. Revisiting your agreements may be something to do if you're part of a dance company or some other company that is has contracts that you've had to sign. So I know we've got about 5 or so minutes left. Were there any other questions that have come through or anything that anyone want me to go over again? So one question, can you provide more detail about the process to register a copyright? Sure, it's pretty straightforward. And it's something that I recommend people try to do themselves. I mean, you can have an attorney, and for some complicated things, it may be worthwhile, but go to the copyrights.gov, if I remember correctly. It's been it, but go to copyrights.gov. There's a whole guide for the copyright. And then what happens is you're going to file online. There's a application process online that you'll fill out. The most complicated piece of it is probably figuring out what type of copyright to get. Keep in mind, you can't copyright a process. I may have one PowerPoint of a whole series of curriculum that I finished. I can copyright that PowerPoint and then go back and copyright curriculum. So sometimes distinguishing between those can be tricky. The guide is really helpful because it does outline some of that. But you go online, you answer a series of questions that try to figure out where you should copyright. You submit your application, $50 right. The Copyrights Office is super duper helpful. It takes a minute, so keep that in mind. On average, it's been about 6 months before I heard back from them. I think that's what they tell you on the site. So keep that in mind. If you have something coming up that you want to make sure when you launch, you have a copyright, you may want to start that process sooner than later. But they'll reach out and let you know that they've received the copyright and whether they agree with the copyright. If they think that the copyright is appropriate for you, they'll actually tell you what they think is appropriate for you. So I think it's incredibly user-friendly, worthwhile. $50 to protect yourself. It is confusing. What people do is maybe call me and have me consult in terms of what to look at. But again, the advice is more than happy to help with that too. They will not give legal advice. If they think a category doesn't, then oftentimes they'll say, what we've done is we've placed it under the category, and then you're good to go. And they'll send you the certificate maybe a couple of months later. So it's pretty much a straightforward process. Now, I will also say that was 6 months ago. There's a lot going on, so it may have changed a little bit, but that's the case. Does it make sense to copyright something that changes frequently like a PowerPoint? That's a good question. So it comes down to what's in the PowerPoint. Is it important to you? And what would the damages be if it was copied? Let me know if it's worse than the earphones, or if I should try the earphones again. I hear audio is messing up again. This helps. So what I was saying is, it really just depends on, turn my volume up. It really just depends on what's in that PowerPoint and what's important for you. If you're going to do it every month, I probably wouldn't copy it that often, and maybe you go in biannually and update in terms of copyright office, which you can't update it. You really can update it as much as you want to. It's just a matter of paying each time that you update it. But things that you're going to be doing quite often, you may just do updates periodically as opposed to each time you update, unless it's something super important, and unless you're presenting it, for example, like a TED, where there's going to be a lot of publicity. You might be worried about someone actually taking in terms of your content and using it. So it's very fact specific, but very good question, because it may be that it doesn't make sense if giving talks to a small audience for me to be doing that regularly. See, make sure I didn't miss any other questions. Oh, and to that point, there was one other I wanted to add on. Oh, with the process for copyright. Again, keep in mind, videography, or things that can't be copyrighted, it may be worthwhile to look at a patent, or it may be worthwhile to look, yeah, you wouldn't necessarily do a trademark. It may be worthwhile to look at a patent. So certain processes and things like that, it's worthwhile to look at a patent. Obviously a little bit more expensive, and usually an attorney is needed to help with those things. But as I mentioned, there's just certain things that for whatever reason aren't considered original, and so you wouldn't be able to get a copyright for that. So I know it was super quick, and apparently I would not want to cooperate today. It happens. I will have this PowerPoint available to friends, of course, and I usually provide a frame, so I'm happy in terms of like a Word frame. Most of the PowerPoints have what you need in there for you if anyone will frame to friends to, but it's a lot of stuff. So appreciate so much you all being patient and for joining me today. And let me know if I need to do anything else.